All right, we'll start now. Today we begin the resentencing hearing in the Menéndez Brothers case. What's important to know is that we always anticipated, as far as the district attorney's office goes, that we would be here for a resentencing hearing, because there was two ways to get here. The first way is that the court initiated its own motion for a resentencing hearing, and we have said all along that we were prepared to go forward with that court-initiated motion. The prior district attorney had initiated his own motion. We opposed that motion because we basically said that the prior district attorney had left out the majority of the key facts in making his motion, and we wanted those key facts before the court. But either way, we anticipated having a resentencing hearing starting today. Now, with respect to resentencing, what you have to appreciate is what that concept actually means. A resentencing statute doesn't exist in most states in the United States, because the idea is that if you're going to challenge your conviction and your sentence, there are plenty of different types of appeals that are available to the typical defendant to do that challenge. A defendant can appeal their sentence directly, as was done in this case. The Menéndez brothers took their sentence and their conviction to the California Court of Appeals, and it denied that appeal. They then took it to the California Supreme Court, and it denied that appeal. Then you can go a second route, and you can do a habeas petition. The Menéndez brothers availed themselves of that opportunity, and the California Supreme Court again denied their habeas petition. Then they went the federal court route, and they filed a habeas petition with the U.S. District Court, which denied their habeas petition on the federal grounds, and they took that up to the appellate court, the Ninth Circuit Court of Appeals, and it too denied their Court of Appeals petition. So 5 different courts evaluating the Menéndez conviction and evaluating the Menéndez sentence have turned those appeals down. But California has this additional statute called resentencing. And the idea was that resentencing was not designed to let every murderer who's had their convictions affirmed by 5 different courts of appeals to let them out. And the resentencing statute said that in those unusual cases where a defendant has met the criteria for resentencing, including accepting full responsibility for the range of their criminal conduct, including demonstrating rehabilitation within the prison system in which they exist, assuming that also that when they've been in prison, that they didn't commit certain violations showing that they were not ready to be released, that in those fairly rare situations that a court now has the power to actually do something that hasn't been done in this case for over 30 years, which is overturn effectively the jury's conviction and sentence that was for a first-degree murder conviction of Jose Menéndez with special circumstances, a first-degree murder conviction of Kitty Menéndez with special circumstances, a sentence that then was life without the possibility of parole, which has been the sentence for over 30 years. So now in this resentencing procedure, they are asking the court to go ahead and effectively overturn that sentence and turn a life without the possibility of parole sentence into a life with the possibility of parole. We have said with respect to resentencing that our position is not no, or it's not never, it's not yet. And the reason we said that is that the Menéndez brothers have failed to come clean with the full extent of their criminal conduct, their cover-up, their lies, and their deceit over the past 30 years. As we've explained, the Menéndez brothers persist for 30 years, as recently as 2024, in insisting that the reason that they killed their parents, and when I say their parents, I mean their mother and their father, is not because of the sexual abuse. When they testified at trial, they were asked that question specifically. Was sexual abuse the reason that you killed your mother and their father? The answer was no. They said the reason they killed their mother and their father was that they believed on the night of August 20th, 1989, their mother and their father were going to kill them, so they had to kill their mother and their father first. That has always been their defense, the self-defense defense. And we have shown through an extensive analysis of 50,000 pages of trial transcripts over 2 trials, of hundreds of hours of videotape testimony, of a review of prison files, interviews with the Menéndez family members that I have personally had, a review of also prior prosecutors and law enforcement that self-defense defense is a lie. It was a lie back in the 1990s when they presented it at trial and the jury rejected it, and it is a lie today. The Menéndez brothers engaged in a deliberate, premeditated killing of their parents based on buying shotguns 2 days before the killings, going ahead and having a pre-planned alibi for the night that they were going to kill their parents, killing their parents in a methodical way to make it look like a mafia hit by shooting their father through the back of his head, their mother as she lay bleeding on the ground, reloading a shotgun and shooting her point-blank range through her cheek, shooting the parents afterwards through the kneecaps to make it staged like a mafia hit, and then running out to the police after they called the 911, shouting that someone killed our parents and that the Menéndez brothers were going to find that person and torture them. All a lie, as was the self-defense defense. They even added additional lies when Lyle Menéndez tried to get one of his girlfriends to say that the girlfriend had been violently raped by the father. A total lie. Lyle Menéndez and Eric Menéndez got another of Lyle Menéndez's girlfriends to say that the mother had tried to poison them. Again, another lie. And the Menéndez brothers have never come fully clean with all the lies, cover-up, deceit that they have told for the past 30 years. When and if they do, and they do it sincerely and unequivocally, to the satisfaction not just of the district attorney, but ultimately the court that is going to hear this type of testimony, then the Menéndezes will be ready for resentencing. Then the Menéndezes will show full rehabilitation. Then the Menéndezes will no longer constitute a risk of danger to society. And we started with this analysis that we presented, but most recently the analysis was corroborated by 2 comprehensive risk assessments done by board-certified psychologists for the Board of Parole that was released about a month and a half ago. And what these comprehensive risk assessments essentially said is that the Menéndez brothers had been raised in risk level from low to moderate risk of violence should they be released. And what they focused on was not just the rehabilitative efforts, which the psychologists all noted and commended the Menéndez brothers for their different and extensive rehabilitative efforts. But what they were concerned about that posed this risk of violence was a deceit that the Menéndez brothers had engaged in while their resentencing motion was actually in play since October 2024. Lyle Menéndez had engaged in deceit by violating the rules and bringing a cell phone into the prison. Just when you would think you would be on your best behavior, as a court is going to consider your resentencing motion, Lyle Menéndez smuggles a cell phone into the facility. And why is that important? Well, a cell phone is not a monitored device by the prison. Every single communication that you have, if you want to speak on a phone or a tablet, there's actually a recording saying it's being monitored by the prison, but not if you bring in a burner cell phone, which is exactly what he did, and he got caught. Same thing with Eric Menéndez. Another, in January of 2025, he goes ahead and violates the prison's rules and brings in a cell phone as well. He also admits to engaging in the purchasing of drugs with other inmates in years before, helping inmates engage in tax fraud. Again, what the psychologist looking at this said is that this shows that notwithstanding those rehabilitative efforts, their risk level is no longer low. It is moderate. There's a moderate risk of violence because if the Menéndezes are released, they're going to head and not be in a highly structured setting like a prison. And if they can't follow the rules in prison, then the confidence level of these psychologists have dropped on whether or not they will now pose a risk of violence in society. So the court today will now consider evidence. The Menéndez brothers' counsel will most likely present a series of witnesses to try and provide additional evidence to the court. The prosecution has been doing just that, providing the court with as many facts in order for the court to make this final determination on whether or not the Menéndezes have been rehabilitated and constitute that risk of danger to society, that if they don't constitute it, they can then have a resentencing And if they do constitute it, then the resentencing will result in not being effectively resentenced. Because let me leave you with this, what the three options are for the court to do in this case. The court had the obligation, once it made a finding, essentially, that it was going to go forward on its own motion and the people's motion to have the resentencing hearing itself. But that doesn't mean that the court is obligated at the end of it to actually resentence the Menéndez brothers. The court is not allowed to increase the sentence to the Menéndez brothers, but it is under no obligation to actually change the sentence for the Menéndez brothers. So that is one option. That after hearing all the evidence, the court decides not to change the sentence. The second option is that the court does resentence the Menéndez brothers to a sentence of life with the possibility of parole. At that point, the Menéndez brothers will then go to the parole board. If the parole board were to grant parole, or even if they were to deny parole, it would end up with Governor Newsom, and he makes the final determination, he and he alone, on whether or not the Menéndez brothers will ever get out on parole. But there is a third option for the court to engage in today. Because when people talk about the sentence, the Menéndez brothers sentence, there's actually two sentences at play. One sentence was the sentence for the killing of Jose Menéndez. As a first-degree murder violation with special circumstances, the sentence for the killing of Jose Menéndez was life without the possibility of parole. But the second count was dealing with Kitty Menéndez, a separate sentence. And that sentence also was life without the possibility of parole for the sentence of Kitty Menéndez. So there is a possibility where a court could resentence the Menéndez brothers based on the Jose Menéndez killing and murder, but choose and then change that sentence from life without the possibility of parole to life with the possibility of parole. But separately, when considering the sentence dealing with Kitty Menéndez, or factors that the court can consider unique to the sentence of Kitty Menéndez, the court can decide not to change that sentence. So even though there will effectively have been a resentencing for Jose Menéndez, there will not be one for Kitty Menéndez, and the Menéndez sentence overall will be life without the possibility of parole were that circumstance to happen. So again, we're going to have this resentencing hearing over the next several days, 2 days. I don't know if the judge will rule at the very end of it. He can decide to rule on in open court at the end of the hearing. He can decide to take it under submission. He might want to write an opinion about what his thoughts are. He might want to hold another court hearing and announce them from the bench. We don't know one way or the other. That will be up to the court. So that is the overview of what was going to happen today and tomorrow. I'm happy to take any questions.
You talked about the risk assessment.